Natalie Rea is the founder and executive director of the International Legal Foundation, ILF, an international non-governmental organization that assists post-conflict and transition countries to establish public defender systems that provide quality criminal defense services to the poor. Ms. Rea graduated from Université de Marseille and from Fordham University School of Law. After clerking for Judge Thomas Platt in the U.S. District Court for the Eastern District of New York and working at Sherman and Sterling, she joined the Criminal Appeals Bureau of the Legal Aid Society of New York, where she represents indigent defendants at the appellate level. Natalie.
Thank you. I come from a very different perspective. I'm from the practical perspective. I also come from the perspective of a public defender in New York City. I think that there are a lot of things wrong with the Armenian system, but I can invite any of you to come to New York, and we could have the same comments. So I think that my first attitude is how are American lawyers seen? I think that we should be our own critics when we go somewhere else. We have something to offer, which is our education and expertise, but we're not making it work here. So let's not fool ourselves, but we still have something to offer. Our organization, yes, we're a grantee, and I'm sure envied by many, of the Open Society Fund. We have a program in Afghanistan, in Nepal, and now in the West Bank. We have a very different model than most, which is that we study the laws of the place where we're going to work. And one of my criticisms of trainings is that people train anywhere. You train in Rwanda, then you train in East Timor, and then you train in Bosnia. We don't do that. We actually take the time to work in the court system of where we are. We rely heavily on lawyers, practicing lawyers in the States, Canada, Australia, who come and volunteer and work with our local lawyers to help them develop their skills. So just as we all learn to be lawyers from some senior associate and partner who abused us, we are happily do that in these 3 different countries. There's no miracle as far as workshops on the effectiveness of a workshop versus the effectiveness of working with a senior lawyer. So in Afghanistan, when we started in 2003 with 2 lawyers, the first woman defense lawyer in Afghanistan, we now have 70 lawyers, 13 offices, and our idea is simply to build an institution that's then turned over to the government, which we're about to do. And ILF Afghanistan is going to become essentially the legal aid office of the Ministry of Justice. We do the same thing in Nepal. So our international lawyers will stay 3, 4, 5 years. And the impact, I think, it seems like nothing to have 2 lawyers. But I'm convinced that our impact happens faster than with any law reform, I'm sorry to say. And I'll give you an example. It's all about, first of all, representing the poor. All our clients are poor because where we work, if you have money, you've paid your way out. So starting there, they're all poor. There's generally the statutes, the legal profession has no culture of defense. I mean, it's not great here, but it's really not good in Nepal, and it's certainly not good in Afghanistan. It's not good anywhere. So the idea that we're just telling people you have rights, and they mean something. They mean something under your laws, not under international standards. You know, I'm just very happy that we have international standards. But they have laws in all these places that nobody's enforcing. So I will give you examples of our impact in practical cases that you can't see if you just read the statute. Because all of us know that the worst thing in the law is the practice. It's not the statute, it's the practice. Okay, it's the practice in New York State Court, it's the practice everywhere. I'll give you an example of the impact of reform versus case by case. In Nepal, in 1992, there was a reform of the Child Act. In the past, a quasi-judicial proceeding, a quasi-judicial officer was the one presiding over cases against juveniles, criminal cases. The person is called Chief District Officer, CDO. This changed in 1992. The Child Act said we're limiting the CDO's, it says the CDO's jurisdiction is now A, B, and C. As far as the C was concerned, it was juveniles with an adult co-defendant. Now, in 2008, when we opened our office, we said, what's going on? Why are all these juveniles in front of a CDO who's not a judge, who basically rounds up kids who are smoking a little dope somewhere in Kathmandu, and then keeps them in for 35 days to teach them a lesson, right? That's basically what happens. So we took case after case to say the statute of 1992 limits the original jurisdiction of the CDO, and you can't have kids here. There's a juvenile bench. Well, it's changed everything for children in Nepal, because now the CDO is not arresting kids because we're going to take them away from his jurisdiction. So they leave them alone. And that's a huge, huge step, and it took us only 18 months to get the case from, whatever cell phone theft or whatever it was, to one that's not mooted out in the Supreme Court. In the West Bank, we opened in September. We represent a lot of juveniles, simply because when you want to make kind of reform, everybody likes juveniles. They don't always like our other clients. So we represent kids. The juvenile correction center, whatever, detention facility, calls us when the police come. So fine, we read the statute, blah, blah, blah. We ask for bail, the kids are out. One kid, it turns out that all lawyers were asking the kid's parents to sign to approve the representation, right? Parental consent for representation. Well, there are huge movement problems in the West Bank. So we have a kid whose parents just can't come to Ramallah. He's poor, they're poor. A week later, he's still in. And we're wondering, where does this parental consent requirement come from? Nowhere. Nowhere. So 3 months later, we opened in September, and last week there was a directive by the court saying you cannot require a parent to sign for the representation of a child over 16. Now, I'm sure that the international community has been working on some children's acts, some, with all due respect, some criminal procedural code, but it just doesn't change, because the reality is the problem is the practice. You can read great codes, but people don't read them. They adjust what they mean to what the practice is. They forget. So this is where, when we work somewhere, we'll sit with the code. I'm an appellate lawyer. I can make anything, say anything. And then I say to my local lawyer, okay, we're going to ask for bail. What do we do? He says, we do this, we do this, we do that. I say, where does this come from? Where? Give me a statute. That's how it is. No, that's not how it is. And once you start looking at where it comes from, you can change things as far as pretrial detention goes so fast with what's there. And I'll close with another example, which is that that we also use speedy trial very, very effectively. Everybody has a speedy trial statute. Every country, they're rare if they don't have one. But basically everybody says, come on, it doesn't work. You can't have a case decided within 12 months. So in Nepal, we had a guy in 4 years. And so I said, statute says 12 months. He said, Natalie, but that's not what it means. I said, that's what it means, until you tell me that's not what it means, that's what it means. We go to court, and he said to me, the judge is going to say, but there are thousands like this. Well, he was right. The judge said to him, I have 5,000 people in this situation. And I told the lawyer, tell them you don't really care about the 4,999. We're talking about this guy. And this guy got out. And since then, there's been another directive by the court saying all these cases must be decided within the next year. So we're small, but we think that, you know, quietly with our little cell phone thieves, we make a difference as far as pretrial detention goes. So. Thank you.
Thank you very much. It's very interesting to hear three different perspectives on achieving more or less the same goals of greater transparency and fairness in these issues, very important issues of pretrial detention. And I think that the final set of comments that Natalie made demonstrate that there are multiple ways to address this. Some might be more effective. It sounds like Natalie's organization is very labor intensive. It requires people not merely training, not merely advising and working with the governments, but actually being on location for a sustained enough period of time. That, it seems to me, just an observation, and then I have an idea of how to open this up for questioning. That is practical only with a tremendous amount of human capital. You know, that is, people familiar with our court system who have the ability, the time, the backing or personal resources to go out and be a part, in a way, of a legal community in an overseas location.